October 11th, 2024, defendant Daniel McGuff was arrested for assaulting, resisting, or obstructing a police officer in violation of Section 750.81d of the Michigan Compiled Laws, which is a felony offense. Mr. McGuff was arraigned that same day, chose to represent himself, and was released on a $5,000 personal recognizance bond. The court scheduled a probable cause conference for October 24th, 2024. Under Michigan Court Rule 6.108, a probable cause conference is an early hearing in felony cases held in the district court after arraignment but before the preliminary examination. Its purpose is to allow the prosecution and defense to discuss potential plea agreements, discovery, bond modifications, and other procedural matters. Prior to the scheduled conference, on October 20th, 2024, Mr. McGuff sent a motion titled Motion for Discovery, Subpoenas, Suppression, and Other Relief Related to Incident of October 11th, 2024, to the prosecutor's office, which forwarded the motion to the district court on his behalf. Mr. McGuff then failed to appear for his court date, and the probable cause conference was rescheduled for November 14th, 2024, in the courtroom of Judge Cedric Simpson in the 14A1 District Court in Washtenaw County, Michigan. Once again, Mr. McGuff chose to represent himself.
So the people versus Daniel Magoo.
Morning. Daniel McGuff.
You're going to represent yourself?
Yes, Your Honor.
Okay, what are we doing?
To begin, I'd like to just announce a brief summary of the incident that happened.
Pardon?
The incident on October 11th, the reason why I'm here. I would just like to announce a brief summary of what happened.
And that's going to get us where?
Well, I did file a motion a couple weeks ago for discovery. I do have a copy of each.
Yeah, no, I saw it. Did you get the discovery?
I did not, but I don't think I properly served it on the prosecutor, so I'm here to do that today. I did serve it with the courts. I did file with the courts.
Oh, no, I saw it. So what do you want me to do with your case today?
Well, I a few things. I want my bond conditions lifted. I want a discovery. I don't know exactly what the procedures here is. You know that wrongfully.
Yeah, I know, because as you're talking and as everything went through, I could tell you didn't know.
Yeah, sorry. But I'm trying my best to do things right. But I just
okay, you haven't started out well.
Sorry. I'm here because I'm told to be here today, Your Honor. That's all.
I know.
So what I want to do
kind of goes out in my name. So yes, I know why you're here. Let me ask you this. You want to represent yourself in this?
Yes, Your Honor.
You don't want help?
No.
Okay. So I'm going to do this. I'm going to apprise you, if you wish to represent yourself, you're constitutionally entitled to do that. I will apprise you that you are before the court on the charge of resisting and obstructing a police officer. You understand that charge?
I do.
All right. That is a felony or a high court misdemeanor. It is punishable by up to 2 years incarceration and $2,000 fine plus court costs. You understand that?
I do.
All right. You also understand, sir, that there can be great peril in representing yourself.
I understand.
You understand also that at this proceeding and any other further proceeding, that the court is going to hold you to the same standard the court would hold anybody else to. And the court will not play favorites. The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. If at any time you wish to be represented by an attorney, and if you cannot afford to hire an attorney, but if you wish to be represented by an attorney, the court will afford you that opportunity to be represented. You understand that?
That process is throughout the whole discovery and trial.
Pardon?
I can be assisted with if
you request an attorney represent you in this matter, the court will at that point, if you cannot afford to hire one, the court will make sure that you have one. If you wish to get your own attorney, the court will afford you that opportunity to do that. You understand that?
I do.
Judge Simpson explains to Mr. McGuff that he has the right to be represented by an attorney, but that he also has the right to choose to represent himself. Under the Sixth Amendment, a criminal defendant has the constitutional right to the assistance of counsel at all critical stages of the prosecution, including pre-trial proceedings, such as a probable cause conference. This right to counsel includes the entitlement to have an attorney appointed at public expense if the defendant is indigent, as the Supreme Court established in the 1963 case of Gideon versus Wainwright. At the same time, criminal defendants also have the right to forego counsel and represent themselves. In the 1975 case of Ferretta versus California, the Supreme Court held that criminal defendants have a constitutional right to defend themselves when they voluntarily and intelligently choose to waive their right to counsel. Accordingly, a trial judge like Judge Simpson must ensure that a defendant understands the risks and disadvantages of proceeding without counsel. But if a defendant such as Mr. McGuff understands the drawbacks and still wants to proceed in a pro se capacity, the judge must allow it.
So what do we wish to do today?
I would like to first file a request for suppression of this evidence until full
Suppression of what evidence?
of body cams, squad footage.
On what basis would you be doing that?
Miranda versus Arizona.
Which says what?
That I have that I was not read my rights prior to being detained, and because of that, any violations that I could have possibly said that could impede the fair of my case.
That's your basis for the suppression of body cam?
That I have the right to be read my Miranda rights and know that anything that I say can be used against me. I was not notified.
So that's your basis
to suppress
the body cam.
I'm not trying to suppress it from the court to see. I don't want it in the public domain. I don't want it. Anything that happened, I was on the scene. The police were on the scene for 2 minutes. They were dispatched there over a fight.
I don't know what. Okay. You're going to have to put more in writing for me to even understand that, because as it stands here right now, based upon what you told me, I'm going to deny your motion.
Deny my motion to suppress under Miranda?
As you're calling it, your motion's denied.
Mr. McGuff moves to suppress the body camera footage from his arrest because he was not read his Miranda rights prior to his detention, and Judge Simpson denies his motion. A motion to suppress is a request that a court exclude certain evidence from consideration because it was obtained in violation of the defendant's constitutional rights. In the 1966 case of Miranda versus Arizona, the Supreme Court held that statements made by a suspect during custodial interrogation are inadmissible and therefore must be suppressed if the suspect was not advised of their rights to remain silent and to have an attorney present. However, the Miranda requirement only applies when both custody and interrogation were present, meaning that the suspect's freedom had been significantly restrained and law enforcement was actively questioning them to elicit incriminating responses. Routine investigative questioning or detention before formal arrests do not, by themselves, trigger the requirement for Miranda warnings. Additionally, even if Mr. McGuff was subjected to custodial interrogation without Miranda warnings at some point during his arrest, the absence of warnings would not bar the admission of the body-worn camera footage. The Miranda rule protects against the use of compelled testimonial evidence, not against the admission of physical evidence. Therefore, while any unwarned custodial statements by Mr. McGuff could potentially be excluded and redacted from the body camera footage, it is highly unlikely that the video itself could be suppressed on the basis of a Miranda violation.
Maybe I'll formulate my request a little more precise to my specific conditions, but I also am requesting that there is full discovery in this process.
Okay. Have you sent a request to the prosecutor's office for discovery?
I have not. Nope.
Have you asked them, how do I get discovery?
No, I will be doing that.
Do you ask anybody how to get discovery?
I asked a couple of the clerks, but they can't, give too much legal advice. So I'm trying to take as much responsibility for this as I can.
Okay, well, I'm gonna, at this point, deny that motion because there hasn't even been a request for discovery. If you don't get something, then you bring a motion for discovery.
Okay.
Next thing you want to do.
Discontinue all hearings until there's substantial evidence on file.
Okay, that doesn't happen that way. I don't know what discontinue all hearings mean.
I don't know either, Your Honor. I'm just represent myself over here.
This is going to be a long process if you just are throwing stuff out there.
I tried to prepare my best for this. I'm really
okay. This was your best. Then you may want to consider getting an attorney, but I'm going to let you go because you have a constitutional right to do it. But this is going to be a long, arduous process if we're going to go at this rate.
What does the prosecution expect next in this case?
Pardon? What do you mean?
You're asking me for what I want out of this case and what I expect.
I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
That's not going to happen.
Okay, so
I mean,
what do I got to do?
Going home is an option, but the charges aren't going anywhere.
I understand, and that's the end goal of where I want to be one day, acquitted of all charges.
Yeah, I don't mean to interrupt, but I am from the public defender's office. I'd be happy if the court wanted to pass to talk with this gentleman.
He says he wants to represent himself, and if he wants to talk to you, then yeah, I mean, I know, Mr. Getty, and I appreciate it, but what do you want to do, sir?
I'm not sure what you're asking me. What are my options, sir? Your Honor.
All right.
What do I want to do?
Here's what I'm going to do. I'm going to take a break because I have to have something happen before noon. I will call the Spanish case up afterwards. I will also then call the one plea, maybe, that we have, and then I'll recall your case in the next block.
Okay.
And then maybe between the time I leave this bench and come back, you'll figure out exactly what you want to do.
Yeah, I'll
maybe how to do it.
I'll do that.
Or maybe if you want an attorney to represent you to help you through this process. Because otherwise, this thing could much go south for you.
Yeah, I understand.
Not be good. But I'll let you think about that. That's your call.
All right.
Court's in recess.
The court takes a recess, and Judge Simpson indicates that he will call additional cases before recalling Mr. McGuff's case to give him some time to figure out what he wants to do next.
Court recalls case People versus Daniel McGough.
Pass along to the people.
Your Honor.
State your name.
Daniel McGough.
All right.
Your Honor, when the court passed this case and left the bench, the defendant did hand me a copy of his motion. I took the recess of the court to file a response. I hand delivered it to the defendant as well as handing the copy to the court. If I may just respond to the record.
Yes.
Thank you. So this motion was sort of put in 3 different sections, for lack of a better term, and they seem to all, like 1 through 11 in each section seems to be the same item. So I only responded to the middle section, which were the motions and requests. The first motion was to compel the testimony of officers at a deposition. I'm asking the court to deny that. As the court is well aware, depositions are not appropriate in criminal court. Does the court want me to go through each one and then make a ruling on all, or do you want to do one at a time?
Let's do one at a time.
Okay.
All right. You got any response to the people's response?
Not for that, Your Honor.
No. Motion denied.
Thank you. The second request is request for discovery, where the defendant appears to be requesting that we produce different discovery items, as well as there's a sentence here that says the defendant possesses exculpatory video footage. Request an opportunity to submit it for review. If he wants to give us something, that's fine, but I just think he should go through the normal discovery process, and I'm not saying the court not order what he's requesting in number 2, because it doesn't appear that there's been any request filed for discovery that hasn't been fulfilled or completed at all.
Well, here's what I'm going to do, at least at this point, is I'm going to deny the motion, that portion of the motion also. When he submits his request for discovery, then I'm going to deny that one specifically without prejudice. That way he can raise whatever issue he may have.
I agree completely, Art. Thank you so much. Number 3 was particularly troubling to the people, as it appears to be a request for the people to get medical records for some person and give those to defendant. I responded that request was unclear, but it appears to be that the people execute a search warrant to obtain medical information for an alleged witness who does not appear to be mentioned in the police report currently in possession of the people. Unless otherwise directed by the court, the people would think that people do not intend to execute a search warrant to seek out private and potentially privileged medical information for this person.
Your Honor, in response to that, I have a FOIA records describing the witness and his shirt that he was wearing, which is the reason why the deputies or the detectives were dispatched to the Puffer Reds parking lot at 3 a.m. that morning. I also have a picture of the witness being right there when I got arrested. I mean, I can show you it. It's quickly available here for me to show you, but I mean, he's really within.
I really would be
grasp.
The defendant showing anything to the court that he has not disclosed to the people.
So, given that I do have FOIA on my CAD records for the dispatch record of police when they made comments saying there's a Huron Valley ambulance dispatched for a person due to high intoxicants. I wasn't dispatched through Huron Valley, but this is in my police report. I think this is valid enough to say that he is a part of the same scenery and event.
Do you have a name?
His name is Jacob Spalding. I've known him for 15 years. I was with him throughout the course of the night and
So you want his medical records?
I want to, first of all, subpoena him to get his witness statement on record officially. And I would also like his records due to the nature of why they.
I'm not going to order. I mean, I'm not going to order medical records. If you tailor a request for something that isn't available in another fashion, then that's fine. But I'm going to deny that one.
Yeah, a lot of my civil procedures I will be correcting and will not have any more problems with. But as for right now,
your civil procedures,
I'm trying to follow the rules of federal civil procedures, and this is my
federal.
Yeah, this is.
Yeah,
I think so.
Okay, so we're a state court.
Okay,
and this is criminal proceedings.
Then thank you for your guidance.
Yeah, so you might want to start there.
Okay.
Okay.
Mr. McGuff states that he is trying to follow the federal rules of civil procedure, and Judge Simpson advises him that he is in state court and that the case is a criminal proceeding. In the U.S. court system, there are two main categories of court proceedings: civil and criminal cases. Civil cases involve disputes between individuals or organizations, such as contract issues or personal injury claims, and are about resolving private conflicts or awarding money damages. Criminal cases, on the other hand, are brought by the government against someone who is accused of violating criminal law and can result in penalties like fines, jail time, or probation. The federal rules of civil procedure, which Mr. McGuff told Judge Simpson that he was trying to follow, govern how civil cases are handled in federal court. However, they do not apply to criminal cases or to cases that are filed in state courts, which operate under their own procedural rules. In Michigan, criminal proceedings are governed by the Michigan court rules, particularly Chapter 6, which sets out procedures for state criminal cases. Because Mr. McGuff's case was a state felony prosecution, not a federal civil action, he was required to follow the Michigan court rules for criminal procedure rather than the federal rules of civil procedure, which have no application to his case here.
So that 3 is denied.
Huh?
3 is denied, Your Honor.
The whole motion's denied, yes.
Thank you.
All three parts.
Number 4 was to subpoena a witness. I just responded that the defendant should follow the subpoena process that's available to him.
Understood.
Okay. Number 5 was that the defendant is requesting the report produce all audio or video recordings. I said that he should go through the discovery process. ask that motion at this point, like, no,
It's denied.
thank you.
You can get
Number 6,
to her.
the people, I'm not exactly sure, there's a motion to seal statements?
I don't know what that meant.
I don't either.
What does that mean?
It means any statements that I made under stress to either the police officers when they were questioning me or before, after.
What do you want to do with them?
I would like to suppress them so that they don't hinder my trial experience, as I was not
What does that mean?
well, I was not given proper notice of my rights when I was detained, and I was questioned thoroughly
You
afterwards.
have to file a motion. You'd have to lay out specifics as to how and or another any statement that you made, which it doesn't sound to me like was the subject matter of necessarily an custodial interrogation, but it doesn't really matter. You're going to need to lay out all the elements of that before I would rule on that. But in its form and as it sits right now, that motion's denied without prejudice.
Thank you, Your Honor. My response to number 7, which is the defendant is notifying the court of exculpatory video evidence. Okay, I don't have any response to that, really, beyond the fact that it seems that these are videos the defendant has, and that he hasn't received any videos from my office yet, so I don't see how
I have
to
video.
respond to
Sorry.
any piece of this.
I have videos, both FOIA requested from the Ypsilanti Police Department and my own. I was formalizing the process for the prosecutor to build her prosecution.
To do what?
When I requested discovery items that I'm going to do following the rules of civil procedure, that's what I was, yeah.
So this last one, what are you going to do with that? What do you want the court to do?
I want the court to find on what grounds throughout the discovery process that I'm guilty of these crimes.
Okay, sir, it doesn't, you seem to want this process to work away, it doesn't.
Maybe that's a disadvantage of being pro se, Your Honor.
Yes, there are huge disadvantages because I think you know what you're doing, but you don't. It's become readily clear to me. You have no idea what you're doing.
Right.
And so I'm going to ask you, and it's going to cause some difficulty for you. So I'm going to ask you again, do you wish to be represented by an attorney?
I do not.
Okay. Motion denied.
Number 8, defendant requests the court cancel all current bond conditions pending the.
Motion denied.
Thank you. Motion to continue proceedings. People weren't opposed to adjournments, but this is actually kind of includes several things. The request is to continue all scheduled hearings until requested testimony, evidence, and hospital records are provided. So I don't have an issue if the defendant needs more time to be prepared to have a hearing, but I do have an issue if he's trying to say that he can't do anything until we need somebody's medical records. So I'm going to get a search warrant for somebody's medical records and depose officers in the criminal case.
Which both of those have been denied. So by default, that would have to be denied if that's what he's asking.
I've made a note of the new address mentioned in section 10, and then there's number 11 is to seal all indictments. I don't know what this means.
I don't know.
All incident related documents and evidence. I don't know what that means.
What does that mean?
It's reiterating the sealing. Anything that I said is really all.
I don't know how that sealing would take place.
Okay.
I think you really need to think about getting an attorney. That part of the motion is also denied.
That's all. Thank you, Aaron.
Okay, so what are we going to do?
Well, I would like a chance to amend the motion.
No, you can file whatever motion you want, but I'm going to tell you something, sir. I'm not going to sit here listening to frivolous motions.
Okay.
I'm just not going to do it.
That's not my intent, Your Honor.
No, I don't care whether it's your intent or not. 3/4, if not 7/8 of that motion that we just dealt with was frivolous. It has no basis in law at all. You're just filing stuff. I'm going to tell you, I'm not putting up with that. Are we clear on that?
We are clear.
So what do you wish to do now? Do you wish to have a preliminary exam set?
Yeah, I'd ask for some, for adjournment in order to review the discovery materials I've produced from my FOIA.
That what?
That I've came up with through my FOIA request. Or I'm going to plan on submitting the procedures as normal through the prosecution too, as well. But I need time to review the
What does
documents.
that mean?
That means I just got the documents and I haven't been able to review them, and I need time to review them. I can't decide on something and request for something right now in this moment if I haven't reviewed evidence.
So all you want is an adjournment?
After this response that I submitted to her and she submitted back, yes, sir, Your Honor. Adjournment for discovery materials.
You know something, sir? Just because you use what seem to be legal words and try to place them into a sentence doesn't mean that it makes sense.
I understand that, Your Honor.
No, I don't think you do. I think you were just placing words in sentences, thinking that because what you're asking for makes no sense. And if you think it does make sense, then maybe this court needs to send you for a competency. And I'm not saying that jokingly. This doesn't make any sense. I'll grant your adjournment. Next time you'll need to fill out a sheet to do it, but I'm not going to waste the time today to do it because.
Thank you, Your Honor.
And Your Honor, for the record, I've put the email address the defendant should contact for discovery on this post-it note, which I'm going to place here, and he can pick up. He's indicated he doesn't want to communicate with me about this case.
He doesn't want?
Oh, at
He
that
doesn't want to
moment.
communicate with me about his case earlier, so I'm not going to speak with him today about this case. So I've given him the post-it note to get discovery.
Oh, yeah, that's a good way to get this going. All right. Probable cause conference. Let me at least have some turkey before I have to deal with this again. December 5th.
At Mr. McGuff's request, Judge Simpson adjourned the probable cause conference until December 5th, 2024. Mr. McGuff has become somewhat infamous in the online court watch community after multiple memorable court appearances, and as of the date of writing this episode, his case is still pending. The probable cause conference that we covered today demonstrates the challenges that arise for all parties involved when a criminal defendant chooses to represent himself. While every defendant has the constitutional right to proceed without counsel, doing so often places them at a disadvantage, as the legal system relies on complex rules and procedures that can be difficult to navigate without formal training. Judges, in turn, must carefully balance a defendant's right to self-representation with their duty to ensure that the proceedings remain fair, efficient, and consistent with the law. This episode highlights the tension between those two responsibilities and the difficulties that can emerge when a defendant's lack of legal knowledge collides with the formal requirements of a criminal court. Let us know if you want to see what happens next in Mr. McGuff's case, or if there's another case or courtroom interaction that you'd like us to cover in the comments down below. Thank you for watching, and don't forget to subscribe and share so that we can foster a